Case of the people versus Zadropko. Is it Kitanov?
Mark Brown, Deputy Chief, written on behalf of Mr. Kitno. State your name for the record.
Stratford Kitno.
Okay, so they're still working.
All right, what are we doing?
There's a mitigation report that's outstanding. We probably need a 2-week adjournment to make sure that gets completed.
It's not objection. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
So what was the date again? Your Honor?
August 7th.
Thank you so much.
The last.
Court calls case people versus Sean Hardman.
Good morning, Your Honor. Christina Costantino, standing in for attorney of record Sydney Rushing on behalf of Sean Hardman. Unfortunately, Judge, it doesn't appear that Mr. Hardman is here. I did look for him in the galley, and I don't believe he is here. I'm sure there's a very valid explanation for his non-appearance, but we would ask the court to consider an adjournment.
Just putting up the bond violation.
I do see it. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Thank you. Oh, rushing. She should be here to take her own bench warrants. Court calls the case, people versus Nicole McCauley.
Manager, Marshall Feaster, First Assistant Public Defender, on behalf of Ms. McCauley, who is approaching the podium.
Oh.
Good to see you, Judge. State your name for the record.
Nicole McCauley.
Thank you, Judge. I have taken the
It's
chance.
nice to see you.
Yeah, you as well. You as well. Find my script. Sorry?
Kind of missed you.
Well,
Where you been?
I miss being here, Judge.
There you go.
I
Otherwise, you would be here.
don't make my own assignments, Judge. I go where they tell me.
Oh, you've got some pull. Anyway.
It's good to see you. I've spoken to Ms. McCauley, Your Honor. I believe she's requesting an adjournment so we can review the discovery that was tendered by the people.
All
She
right.
does want me to make a bond request, Your Honor.
Go ahead. I will. Well, first of all, I'll adjourn it to July 31st.
Okay. Sorry, Judge. Ms. McCauley has a case out of Wayne County that she has a release to a treatment facility on to Naomi's Nest.
Yes.
She is asking if Your Honor might consider a release to treatment in this case as well.
That would be, it was at least an inpatient at that facility.
Yes, sir.
Okay, once again, I'm not gonna have a problem with that.
Fair
So
enough.
if you submit a stipulated order to me allowing that release, but unlike what Mr. Elman did, you can put on there that if she fails or leaves, we'll need to return her to Washington County Jail.
Fair enough. Will do. Thank you, Judge. Okay, so he said,
All right, so at this time, our bond will continue.
thank you.
Court does call the case, people versus Todd Averman.
And Alex Warren Green on behalf of Mr. Ammerman. Mr. Ammerman, can you state your name for the court, please?
Metwali. Mr. Metwali, state your name for the record.
Ahmed Mitwalli.
Thank you, sir.
Your Honor, today is the date and time set for the probable cause conference. That's a little bit of history. Mr. Metwali was originally scheduled for a competency review. He has since been found competent. There's a criminal responsibility evaluation that is still outstanding. However, we have chosen to waive our right to preliminary examination and agreed to have this case bound over to circuit court, where we will await the finding on the criminal responsibility.
Sir, is that correct? You're waiving your right to have a preliminary examination?
I really do not understand this part of the process. I was going.
Okay, so let me just ask you this. Right now, this is set for a probable cause conference.
Yeah.
A number of things can happen at this probable cause conference. One is that I could set this for a preliminary examination. Basically a mini trial in essence, except typically the defense does not call witnesses. At that proceeding, the people would be required to show two things by a standard of probable cause. First, that there was a crime or crimes committed and that you committed those crimes.
Okay,
All right? You understand that?
yes, so,
So what your attorney's indicating to me is that you do not wish to have that hearing and that you wish to proceed to the higher court, that being the circuit court, for further resolution of this case.
And at that
well,
point, we will be,
I was going to plead not guilty by reason of insanity.
hold on. Hold on, we talked about this. So the way to do that is like I told you, it's the way we're gonna set the court.
Okay,
For this criminal responsibility, but you not understand that?
yeah, so,
Okay, yeah, so, you need to stop talking and listen. We've already talked about how to proceed to do that.
yeah.
You agree that you did it this way. Do you still agree to do it that way?
I just do not understand if there's any other option to wait for the criminal responsibility. So I want to wait for the criminal responsibility report.
You want to wait for that?
Yeah,
Okay. So that's what your attorney's trying to do. He's trying to
Okay.
get you to circuit court because this court would not deal with criminal responsibility.
okay,
That's what we got.
All right?
okay,
So you would like to waive your right to have a preliminary examination?
yeah,
Okay, and you understand that that's that proceeding or hearing that I talked about, where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yeah,
Okay, you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
yes,
All right. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all four counts.
Thank you, Your Honor. We acknowledge receipt of the information. We waive its reading on the record. My client has executed the examination waiver and he will be entering a plea of not guilty.
Defendant having waived.
Also, I want to clarify that it's confusing when my actual lawyer is not here. Because Jay Bellinger is my lawyer.
Okay, so Jay Bellinger is a part of an office
Okay,
of which the gentleman standing next to you is second in charge.
okay, because it's confusing because I thought my lawyer would be here. And my lawyer had.
Well, they are. Mr. Bellinger has, I'm sure, spoken with Mr. Brown and given him specific instructions as to how Mr. Brown is to handle this case, which he's probably done admirable.
Thank you. I have.
Okay,
Okay?
okay,
All right.
Thank you.
So defendant having waived reading and pleading not guilty to all four counts, court will enter that plea. Pretrial in this matter will be set
August seventh at 1:30 with Judge Slay.
August 7th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
is that the circuit court?
Yes, that's in circuit court.
Yes, that's what.
Okay.
Bond will continue. Thank you.
Thanks.
Thank you, Your Honor.
All right, let's talk about that. This hearing delivered a full spread of courtroom energy, some calm cooperation, some procedural confusion, and one defendant who took the scenic route to understanding how court representation actually works. We kicked off with Africa Kittenoff's case. The defense and prosecution were still waiting on a mitigation report, so everyone agreed to a 2-week adjournment without objection. Bond continued, and things stayed polite and professional. The hearing then moved to John Hardman. Unfortunately, Hardman wasn't in the building. Despite a good faith attempt from stand-in counsel to vouch for his non-appearance, Judge Simpson wasn't playing guessing games. A $25,000 cash surety bench warrant issued immediately firm, fair, and to the point. Then came Nicole McCauley's matter, which had a little more personality. Her defense attorney, the first assistant public defender, brought some friendly banter to the podium, exchanging lighthearted greetings with Judge Simpson. McCauley herself joked that she missed being in court, to which the judge responded, "No, you don't," a classic moment of judicial honesty. But things quickly turned practical. McCauley had a case out of Wayne County and was requesting inpatient treatment at Naomi's Nest. The judge didn't blink. He approved the release. To treatment as long as the order included a clause for her return to jail if she failed or left the program. Bond continued, and we moved on with a smile. Then we got to Todd Averyman and Mr. Ahmed Metwali, and this one was a ride. Metwali, facing 4 charges, had previously been found competent, but was still waiting on a criminal responsibility report. His counsel tried to waive preliminary examination and get the case bound over to circuit court, where they could eventually enter a plea of not guilty by reason of insanity. But Metwali wasn't so sure. He interrupted to ask if there were other options, maybe wait for the responsibility report first. Judge Simpson, trying to maintain order, explained in plain terms, "This court doesn't deal with criminal responsibility. That's a circuit court issue." After a few more interruptions and questions, Metwali finally agreed to waive the hearing and proceed. Judge Simpson confirmed the waiver and bound him over on all 4 counts. When the defendant then asked why, his real lawyer wasn't there. The judge broke it down, his actual lawyer. Jay Bellinger was part of the office, and the gentleman next to him, Mr. Brown, was second in command. As Judge Simpson put it, Brown probably handled things admirably. It was a quick reminder that representation doesn't always mean the face you expect, but it still counts if done right. The courtroom mood ranged from efficient to slightly chaotic, but Judge Simpson kept control. She handled missed appearances with firm accountability, encouraged treatment pathways when appropriate, and explained the legal maze to confuse defendants without losing her cool. Even when someone challenged who their lawyer was, she brought clarity with professionalism and a little dry wit. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.